Hi, my name is Kalief Browder, and I'm the Associate Vice President of Policy at the David Rothenberg Center for Public Policy at the Fortune Society, and welcome to Both Sides of the Bars, a discussion-driven show that examines the criminal justice system from various perspectives, including those most impacted by the criminal justice system. We discuss critical questions about how the current system works, its intersections with social justice, and highlights the efforts that are being made to improve the lives of everyone that is affected by it. We ask you, the viewers, to spread the word about Both Sides of the Bars and share your comments with us on Twitter at TheFortuneSOC and at Katal Center. Today's show is titled Liberty or Liability, the movement to end cash bail in New York State. My guests today are from the Katal Center for Health, Equity, and Justice, Sean Hill, Senior Fellow, and Valdez Heron, Apprentice Organizer. Thank you both for joining us.
Thanks for having us.
Sean joined the Katal Center in summer of 2017 to address and advance speedy trial and bail reform across New York. Prior to joining Katal, Sean was a senior staff attorney with Youth Represent. He also started their Family Stability Project, which expanded the law office's legal practice to various family court matters. Valdez grew up with a passion for politics and an urge to bring great changes to his community in New York City. In 2011, he had the opportunity to get involved with criminal justice reform, work as an intern for the Drug Policy Alliance, working on campaigns related to ending racially biased marijuana arrests in New York City. Again, thank you both for joining us.
Happy to be here.
So, Sean, tell us, what is cash bail and why is this a problem in terms of criminal justice reform?
Yeah, sure. So New York is unique in two particular ways. One is the fact that we actually have 9 forms of bail in our state. And then the second way is that judges are only allowed to make a specific consideration around whether someone is going to come back to court, and that is supposed to influence the amount and type of bail that they set. So when we talk about cash bail in New York State, it's just one form of the 9 forms of bail that judges have available to them. And so cash bail requires that someone make an upfront cash payment. That payment is typically made directly to the court in an amount that's been set by a judge, and they have to pay that amount of money in order to be able to secure their release, or their family members or their loved ones typically are going to have to get that money together in order to be able to get them released. So that's one form of bail that judges can choose from. They also can select from what are called insurance company bonds. So that's the bail bond industry that most folks are familiar with. I think most people who are associated with our criminal justice system or know anything about it are most familiar with cash bail and insurance company bond, because those are the 2 forms that are most often set on cases. But like I said, there are a total of 9 forms, and the 7 other forms would allow people to make no upfront cash payments in order to get someone released. Those are called unsecured bonds, or they would allow for partial payments to be made on the front end. Those are called partially secured bonds, and those don't require any payments be made to the bail bond industry, which still needs a lot of regulation. So in New York, like I said, we do have cash bail, but it's just one of 9 forms of bail that judges have available to them to select from.
But unfortunately, judges generally don't use many of those other 9 forms, correct?
So that's part of the challenge that we are trying to address and overcome here in New York State, is the fact that judges can select from these 9 forms. They're obligated to set at least 2 forms of bail. And since the 70s, when we originally passed the statute, it was passed with the specific goal of expanding the options that were available to judges. So back in the 70s, before we had this new statute, they could only set cash bail or insurance company bonds, and that really gave people very little options. And so they expanded the options to include all of these other forms, and unfortunately, our judges have not been selecting those other forms of bail. It's a combination of problems and issues. The Vera Institute recently published a report which demonstrated that the paperwork that's required for these alternative forms of bail can oftentimes be difficult for clerks and judges and also defense attorneys to be able to handle, but there's just generally a lack of familiarity with the alternative forms of bail, and there's a lack of infrastructure to be able to set those alternative forms of bail in the state.
Yeah, and so there has to be, it seems that there has to be some form of a culture shift amongst judges and district attorneys.
Yes, I definitely think that that's accurate. I think, again, referencing that Vera report, the positive wasn't just that there was this report that found, this lack of knowledge around the alternative forms of bail, but it seems to have had a positive impact on the court administration here in the city in terms of them exploring now simplifying the paperwork that's required for the alternative forms of bail and making sure that stakeholders are generally educated. And so I think that that's a really positive example of the type of culture change that we're going to need to see on a statewide basis and not just limited to New York City.
Yeah, thank you. So Valdez, do you want to share with our viewers some of your personal experience with both cash bail and insurance bonds?
Cash bail is I would say it's a direct payment towards the courts, where you don't have to go through an insurance bond company, and it's direct payment. Whatever the price is, that's the set payment. You pay that, and you're released out on bail. The only thing is that you just show up to court. As far as the insurance bond, the insurance company, the bond companies, how they work is they really don't have regulations. It's more like whatever stipulations they put into play, like you have to abide by those stipulations. Different insurance bonds have different rules. Like you have to check in. Mine was I had to check in once a week. Some do drug tests. Some make sure that you have to have a job. Like it all depends on what they want, and it's not regulated by the courts. So it's really you're just paying money to be free, and also have to abide by a new set of rules. So.
And so if a bail bondsman puts up a bond for someone, they essentially have a lot of leeway to say that you have to check in with us either in person or over the phone at least once a week. We have the ability to show up to your place of work, to your home, I would assume, the ability to drug test you. And what you're saying is that those rules are not regulated by any entity, whether it's a public or private entity.
Facts. That's the truth.
Yeah.
It's not like the court mandates them to give those orders. It's strictly their own choices. So, like, I'll give you an example. For instance, when I was on bail, I was basically coming on the ending of my bail, and they gave me a paper and told me that I had to sign it, basically saying that if I ever went missing on Facebook, they could post my picture and send the picture out to anyone on Facebook to see whether they've seen me. And regardless whether I wanted to sign it or not, I had to sign it, or else my bail would have been revoked. And that wasn't mandated by the court. So those are situations. That's an example of some of the things that these bail bond companies do, like on their own strength.
And so in both cases, in cash and bail bond, most folks will pay that or be assigned that by the district attorney or the judge pre-trial, right? And so do you want to say something a little bit to our viewers about what pre-trial is? Because I think most people, when they hear bail, they don't necessarily have a full context of what that actually means.
Yeah, I think it's something that it took me going to law school to really fully understand when we talk about our criminal justice system. When you're held pre-trial on a local jail like Rikers Island, if you're being detained pre-trial, that means that you have only been charged with the crime, right? And under our Constitution, that means that you are presumed innocent, right? And that's a core pillar of the American judicial system, is that individuals are assumed to be innocent, and the state bears the burden of demonstrating your guilt beyond a reasonable doubt. So when we're talking about people who are being held pre-trial, that means that they're being held on the basis of police allegations and any evidence that was secured by the police, but they're held to a standard called probable cause. So that means that it is a lesser standard than beyond a reasonable doubt what a DA is obligated to prove. So when we're talking about those different standards, that means that we should have different requirements when we talk about holding and not holding people. So when we've convicted someone, that means that they have been found guilty or they've pled guilty, and as a result, if they are detained as part of their sentence, it follows after a guilty plea. When we're talking about pre-trial, that means that I've only been accused of a crime, and we're basing that largely on the word of an officer. And unfortunately, that does not leave a lot of space for judges to scrutinize the evidence that is typically postponed until a trial. So it's important to understand that when we talk about people who are being held pre-trial in jails, these are people who have not been convicted of crimes. They have only been charged with crimes, and the state still bears the burden of demonstrating beyond a reasonable doubt. And unfortunately, unfortunately, when we're holding people pre-trial, it has a lot of negative consequences for the final disposition of their case and how it's going to resolve. And what a lot of studies have found is that people tend to actually plead guilty in order to be able to secure their release. And that's not how our criminal justice system is supposed to operate.
There are over 25,000 people detained in local jails across New York State on any given day. And according to the Vera Institute, nearly 70% are being detained pre-trial. This means, as Sean laid out, they have not been legally convicted of a crime and that they have only been charged. Therefore, they are presumed innocent and are awaiting their day in court. Most detained in jail pre-trial simply because they cannot afford to pay cash bail. So, Sean or Valdez, some people would say that everyone has access to the right of having a bail set. But advocates would say that just because someone has access to it doesn't mean that it's equitable. So what should our viewers know about when someone is given a cash bail or even a bond and someone can't afford it? Like, why is that a violation of their constitutional right? Just because they have access to it doesn't necessarily mean that it's equitable, right? Everyone has equal access, but it doesn't mean equity. So as an advocate, as folks who are directly impacted, why does that create a problem in a system that is designed to deal out, quote unquote, equal justice?
I say the reason why that's unfair and why that's blatant, the way I look at it is that's basically arresting people, or you're charging people for being poor. Like, you know that people are coming from environments and from a lifestyle where they don't have much. Their parents don't have much, so they do whatever it is they do to try and acquire some kind of cash to survive. You're locking people up off of minuscule crimes and then charging them outrageous amounts for bail. If someone is hopping a turnstile, which is just $275, if they're hopping a turnstile, which means they couldn't afford that $275, then why would you charge them $5,000 for their bail? And even with that $5,000, you go to the bond, that's still $500. If they couldn't afford the $275, then how are they going to afford that $500 to bail themselves out? If we know these people, if we know the majority of people who are getting arrested are people who come from poor and low income neighborhoods, then why are we continuing to charge them outrageous numbers that we know that they cannot afford? If we're looking for, we talk about fairness, we talk about equal, by being equal and this being a just and opportune place. There's people who's like very wealthy, they could get arrested for the same crime, and just because they have they have the wealth and they have the capabilities to pay bail, they come home. So the only difference there is that this person has cash and the other person doesn't. So how is this fair? How is that just in society's eyes?
So Sean, do you want to speak a little bit to the socioeconomic issues that kind of like are at the root of many of these issues? For example, the one that Valdez brought up about someone not being able to pay $2.75, which is the fare for entry here in New York City for our metropolitan transit system. So do you want to talk a little bit about that?
Yeah, sure. I think many people, unfortunately, because people do not have regular access to our courtrooms, there are a lot of presumptions that folks make. And one of those presumptions is that judges are setting bail specifically in an amount that people can afford. And when we read our statute, they are supposed to account for the ability of an individual to pay. Unfortunately, what appears in the books is very different from what happens in practice, and oftentimes judges are setting bail not again to ensure that someone is coming back to court, but it's often a vehicle for them to be able to clear their dockets, so their court calendars. So we know that communities are being over-policed, and as a result, they are being over-incarcerated, and an easy way of making sure that someone is not going to have a future court date is to set bail in an an amount that they're not going to be able to afford, and is ultimately going to encourage them to take a plea in order to be able to gain their release. So I think the first place that we need to start is really to scrutinize whether or not judges are actually making these evaluations and setting bail in amounts that are aligned with what people can actually afford. So I think that's the first thing. But I think the second thing that's really lost when we exclusively base, these decisions on how much people are able to earn is the lack of wealth in Black and brown communities in particular, right? So we've had a lot of studies over the last several years, and one such study showed that it would take 225 years for Black Americans exclusively to save their wealth in order to accrue the same degree of wealth that white Americans currently possess. That's 225 years, right? So when we account for the fact that we have these tremendous disparities, another study out of Boston recently showed that the wealth of the Black community in Boston was $8. Right? So these are not outliers. This is the commonality across Black and Latino communities in particular. And so when we don't account for the fact that we have these tremendous disparities across races, particularly when we talk about wealth, it bleeds into our criminal justice system, and it manifests in the fact that we have a disproportionate number of Black and Latino individuals who are currently being incarcerated. And so I think it's just a combination of all of those factors.
Yeah, thank you. During the State of the State address, Governor Cuomo proposed the New York Promise Agenda, what he characterized as a comprehensive set of reforms from arrest to trial that will ensure equal justice for all citizens. One of these measures included overhauling New York's antiquated bail system. To rectify the inequity and injustice created by forcing one to purchase their freedom while presumed innocent, the governor is proposing legislation that would eliminate monetary bail for people facing misdemeanor and non-violent felony charges. Instead, people will be released either on their own recognizance or with non-monetary conditions imposed by the court, such as reporting to a pretrial services agency. For people charged with a violent felony offense, both monetary and non-monetary bail would be permitted, but only after a judge conducts an individualized review of the nature of the case and the defendant's personal and financial circumstances. If monetary bail is set, the court must give the defendant a choice between cash or bail industry bonds and an alternative form of bail, such as an unsecured or partially secured bond. So, Sean and Valdez, break all of that down for our viewers, because that's a very technical way to explain some very simple reforms that the governor is trying to implement, at least what he's saying through rhetoric. So do you want to start, Sean?
Sure. I think what Governor Cuomo has released as a plan is a positive step forward and a step in the right direction. What was reflected in his proposal was based on some recommendations that Katal and a number of other organizations made via a letter back in November, including that the governor not recommend or endorse what are called risk assessment instruments, which have been shown to have some really serious racial outcomes that can be racially disparate, and then also not adding dangerousness outright to our statute, because that would be a shift since the 70s. So I think when, the governor's plan to entirely eliminate monetary bail on misdemeanors and nonviolent felonies is great. I think we have noted that there is some difference between what was reflected in a press statement that was released and also some New York Times coverage, which said that was going to be an outright elimination versus what's included in his State of the State book, which only stated that there would be a presumption in favor of not setting monetary bail on those cases. And so I think one thing is that we absolutely must hold the governor to entirely eliminating cash bail on these cases. A presumption would not be enough, particularly when you account for the fact that in New York State, and this is also the case in a lot of other states, you have in regions individuals who have no legal training who are overseeing court cases. So they are called town and village justices here in New York State. And so they have been responsible for the fact that in upstate New York, the majority of people that are being detained are held on misdemeanors, and that's not the case here in New York City. So I think that only allowing a presumption is not going to go far enough. It has to be a mandate that individuals who are charged with those types of crimes are only going to have non-monetary conditions set, and they should be the least restrictive conditions necessary to make sure they come back to court. Because unfortunately, you can eliminate monetary bail, but if we're then forcing people to subject themselves to GPS monitoring, if we're forcing them to do multiple check-ins via a week, we're increasing the likelihood that they're going to violate some type of condition and subsequently be incarcerated. So we're not going to actually address the issue itself. So I think I'll leave it there in terms of the misdemeanors and nonviolent felonies. And I think there is a good deal that could also be said about the felony matters as well.
So Valdez?
I'll speak on the matter that he's allowing people to, he wants to allow for people to start getting individual, like checking on individual financial status. I agree with that. Like I said, with my situation, I was lucky enough to make bail. My case actually lasted 2 years. So if I didn't make bail, that means I'd have been sitting on Rikers for 2 years fighting my case.
At least 2 years.
At least 2 years fighting my case. Like I said, I was able to make bail. My bail wasn't outrageous. If they actually, still feel like if they look at people's cases directly and see what that person's lifestyle is, what their financial capabilities are, and then set it that way, then it will be way easier for people to bail out and fight their case and come back and forth to court, because no one wants to run from a case. Who wants to add extra trouble to themselves? But as far as the bail goes, like with setting up the bail to what someone can afford.
So let me ask you this: what? Because some people would say, if you can't do the time, then you shouldn't do the crime, right? And so, what would you say to someone who says, you know what, if you can't afford a bail, then you shouldn't have, quote unquote, committed a crime, right? Because there are folks who will be viewing this, who hear these issues that advocates put forth, including myself, that say that this system, the bail system, is another way to just punish a socioeconomic issue that is involved in a person's life, right? So the fact that someone is poor and that they're struggling and that they can't afford bail, that this is another way to punish them, and that the punishment is actually in the process. So what do you say to people like that who say, well, you know what, if you can't afford the bail, then you shouldn't have committed this crime?
I think I would say that, again, this is before people have been found guilty. And I think the story that has definitely risen to the conscience of New Yorkers, and I think has also captured the attention of people nationally, is the story of Kalief Browder. And Kalief Browder was a young man who was charged with a robbery. Right? And on the face of that, we would look at that type of crime and we would say, well, absolutely, this is someone who should have the book thrown at them. And what was discovered after he ultimately wasted away on Rikers Island was that he had never actually committed the offense. So I think that it's important, again, for folks to really understand that distinction between being charged with the crime versus having been convicted. And we know that there are a number of reforms that are sweeping through New York City and in New York State when we talk about holding our police officers accountable and law enforcement accountable. And until we can reach a place where folks feel consistently that we are able to hold law enforcement accountable, we have to create mechanisms to ensure that any statements that are being made by those officers are going to get scrutinized by a judge. And that's really what we're recommending when we talk about building more procedural protections for people who are being charged with crimes as opposed to having been convicted.
Just want to add something also. Like, there's another aspect as far as being a defendant and being on bail and being arrested, and you're away from being held because you can't afford trial, because you can't afford bail. That person could have a job, that person could have kids, that person could be the breadwinner for their family. Now that they're arrested and they're taken away, they're not charged. So they're not
convicted.
Yeah, they're not convicted. They're only being charged for the crime. with that being said, they're taken away for however long it is. Their job is now gone. If, as Kalief Browder's case, he was found innocent, the case was dismissed. If someone else whose case was dismissed and they come home and now their job is gone, they have to come back and go back to tell their job, like, look, it was a misunderstanding. Like, that's a big, it messes up people's lives.
Yeah.
It's a big mess up on people's lives. Like,
yeah. And so just two things to just make clear to our viewers about Kalief's story is that one, he had a bail that was set in his case and that he couldn't afford to pay that bail. And two, that the reforms that are put forward by the governor, he would have not have benefited from them, at least in the way that most advocates would want, right? So just two very distinct points to make. So in the last 2 minutes that we have, why is cash bail, why is reforming the bail system as we know it, why is that important to advocates? Because as you mentioned, Sean, you see this is sweeping across New York City, in New York State, but also across the country, right? There are some jurisdictions that are trying to think really differently and boldly about what to do with bail and how do we actually release people. So why is this so important to advocates, and why is it so important to reversing mass incarceration?
I'll start. The reason why I say it's very important is because bail is one of the main reasons why people are stuck behind bars. It's one of the main reasons why people are stuck behind bars pre-trial. I feel that if we fix the bail, clearly it can't just be me alone, because everyone is starting to realize this, that once we fix bail, we can really address the mass incarceration problem that we have. From once we address the fact that our people, Black and Latino people, we struggle when it comes to financial issues and when it comes to wealth, and bail is strictly based upon your wealth and your financial status, and that's our we cannot combat that. If you want to give us a fair playing field where it's equal for all, then that's what it should be. It should be an equal playing field for everyone.
Thank you. Sean, 30 seconds.
Yeah, I just think that, we have an incredibly bloated prison system, and it is destroying communities, and it is incarcerating our most vulnerable, the people that we should be focused on supporting and making sure that they're leading successful lives. And so I think that the reason bail is so important is to actually ensure that our criminal justice system is, again, not treating people differently based exclusively on their race or on their wealth, and instead ensuring that people are treated equally regardless of those factors.
Well, thank you, Sean. Thank you, Valdez, for joining us today. Thank you to the viewers tuning in. If you're interested in finding out more about the Fortune Society, please check us out on the web at fortunesociety.org or on Facebook by typing in The Fortune Society. This is Kalief Cumberbatch, and I appreciate you joining us as we continue to critically look at both sides of the bars.